In this new segment of Advisor Revelations, the DPL team will discuss how to evaluate new solutions and address current challenges and the strategies that can help you grow your firm and AUM.
This is David Lau, and I've got a terrific guest here today for our podcast. I've got Fred Reish from Faegre Drinker, one of the most, Fred is one of the most influential thought leaders on ERISA, DOL rules, fiduciary implementations. He's been long known in the industry. He's been cited as one of the legends in the industry by Plan Advisor magazine, and it's my privilege to have Fred on to talk about everyone's favorite topic, the DOL rule. And welcome, Fred.
Well, thank you, David. Good to be here.
Yeah, and I should mention I've come to know Fred through our mutual work on the CFP Board Standards Resource Commission, where we talk about such things as the DOL regulation, and among a very esteemed group of people, Fred is definitely the guy everyone turns to for the definitive word and expertise on the regulation. So, Fred, why don't we just start with the DOL fiduciary rule? They've made an attempt at a fiduciary rule in the past. It's been overturned by courts, but now there's a new version out there. And so maybe we can just start with the intent. What is the DOL trying to accomplish with their fiduciary regulation?
Sure. And David, there's a big picture policy perspective on what they're trying to accomplish, and then there's a little bit of history about how they've gone about that over the years. But let me start with the big picture first. The Department of Labor, when 401k plans first came into existence, there were IRAs already, individual retirement accounts, but there was no history of people being in 401k plans. There's no history of rollovers. There's no history of rollover IRAs. Back when the fiduciary definition was originally developed, there simply wasn't a lot of the history that we have now. If you think back to the 1970s and that era, people were mainly in defined benefit plans, and they got monthly checks out of the defined benefit plan. In other words, they didn't get a lump sum of 200, 300, 400, 500,000 or $1 million. It rolled into an IRA with the plan sponsor and its fiduciary saying, "Good luck. We hope you make it through retirement, with income remaining." And so the circumstances changed dramatically. And I would say the focus because of that is on two things. One is rollover recommendations, and the other is investing in IRAs, regardless of whether they're individual retirement accounts or individual retirement annuities, which I think the insurance industry refers to as qualified annuities. So if you want to know where their emphasis is, it's on one, making sure people get really good rollover recommendations and that the money is going to a place where it should appropriately for that person. And two, a focus on how are people who are retiring at 65, say, going to make their money last until they're 85, 95, 105 years old, when folks have had no education or experience in doing that. We're getting our first generation of true 401k retirees. We have no experience. There's no grandparents to have their grandchildren on their knee telling them about, here's how I made it with my 401k. So we're off into uncharted territory, David. And ever since about 2010, the Department of Labor has been trying to change that old 1970s regulation so that it would switch from requiring an ongoing series of recommendations, what they call the regular basis test, to where a single recommendation to take money out of a plan and roll to an IRA would be covered, and where it would be clear that conflicts of interest within IRAs are covered. So the impact is much greater than that, David, but that's where the rubber really hits the road.
Yeah, and some people have described it as really this new fiduciary rule, in effect, is trying to almost close a loophole in the ERISA fiduciary regulations where, sales of, individual annuity products or something were, kind of excluded or found a loophole within that initial regulation where fiduciary recommendations are really required within ERISA. But now, but there's been this loophole for the sale of annuity products and other things, and they're trying to close that gap. Do you think that's a fair assessment?
Yeah, I think it's fair. I think back when a lot of the initial thinking was done about these rules, David, one, there were monthly distributions out of defined benefit pension plans. So there was monthly income coming out of retirement plans rather than lump sum rollovers. So they didn't have to think about it back then because that wasn't the norm. And two, I suspect, although I don't know, David, you would know better than I do, that back in the 1970s, that most annuities were just regular fixed rate annuities, which as compared to most annuities is a pretty simple product. But now we've got registered index linked annuities. We've got, there's just we've got MIGAs. We've got a whole variety of products, some of which are fairly complex. And so now the DOL, I think frankly, whether you like their regulation or not, I think there are statements that it's really hard for the average 401k participant on the street to understand and evaluate all of these complex products. I mean, heck, I've read some of them and I think they're fairly complex, and I do this for a living. So
you and me both. I'm, as you know, in the business and maybe one of the only distributors of annuities that is for this regulation. But yeah, I still, see products that, are so complex, it makes my head spin. So yeah, in total agreement there. So with the, so who do you think is, what is the impact of this rule, going to be on the industry relative to advisors, annuity distributors, carriers? Where do you think the big impacts are there?
I think you need to just break it into three categories, David. One would be broker-dealers for annuity contracts that are securities. Another would be the large insurance companies that have statutory employees. And then the third would be independent producers. So let me go through each one of them in order. For broker-dealers and investment advisors who are less involved in the annuity market, but for broker-dealers and investment advisors and annuities that are securities, they're already operating under PTE 2020-02, under the prohibited transaction exemption. So for them, and on top of that, the SEC rules are somewhat similar to the DOL rule, 85, 90% similar. So I don't see it as being a big change for them. I mean, maybe just having better capturing information about the individual participant and what their individual needs are. I went through the program on your website, David, where you ask all the questions, that's more robust than I think the data gathering that most people do. And so I'm thinking it could lead to something like that, a more robust data gathering, because for a fiduciary recommendation, you want something in the profile or something in your file that says, yes, there's a need for guaranteed income here. So anyway, I could see that, maybe some tinkering like that, getting better information gathering, a better defined process, because with an annuity, the product is the differentiator to a greater degree than with an IRA that's securities based, because that's more services, where the annuity is more product. But anyway, other than that, I think broker dealers and RIAs are, they're going to have to make some adjustments, but they'll be fine. You look at the big insurance companies that have statutory employees that are now going to have to be under 2020-02. At first blush, that could have seemed like, man, that's a really tough job. But then you begin to realize that those big insurance companies also own broker-dealers that are dual registrant broker-dealers and investment advisors. So they've already got 60, 70, 80% of their agents as reps of the broker-dealer, and those guys are already in compliance. So now they can just have one system, PTE 2020-02, that covers their agents their broker-dealer reps and their investment advisor reps. Same people, basically. So one supervision, one set of forms, one set of training. And there are actually advantages to them of this. Then you get to the last category, and it's, as you might expect, I saved the most difficult for last. The independent producers and the independent insurance companies, and the insurance companies that sell through independent producers. David, I won't go on a whole long monologue here. I'll let you ask me some questions, but let me just say that that's where the difficulty is. And we've got a September 23 effective date, and we've got probably tens of thousands of independent producers. And I don't see the amount of communication and effort going on to help them out that's necessary for September 23.
Yeah, that's right around the corner. I mean, that's literally about 2 months from this conversation. And so maybe a lot of them are relying on the fact that the rule got overturned, and we've already seen a lot of legal efforts kind of trying to combat this one. What do you think the prospects of the industry getting the rule overturned or delayed or having any impact on that September 23rd implementation date?
A couple thoughts, David. First, I do agree. I think that a lot of people may be relying on that. Secondly, David, if I get this right, then you ought to take me to the next Kentucky Derby with you because I'm worth betting with. What I'm trying to say by putting it that way is that nobody knows. I mean, you're going to get this lawyer saying that, this other lawyer saying the exact opposite. Nobody knows, and I don't think anybody should rely on it. There are two lawsuits filed primarily by the insurance industry participants, both filed in Texas, two different courts in Texas, that is part of the Fifth Circuit. These are the trial courts, but they report up to the Fifth Circuit Court of Appeals, which is the court that overturned the Obama era fiduciary rule. So and on top of that, you have two very conservative judges. They just happened to, well, not happened. There was forum shopping that basically picked these judges. So I would say the odds are relatively, they're at least 50-50, if not more. But there's also an element of, there is a possibility they will not enjoin the effective date. The first step is going to be, will they or won't they enjoin the effective date? And the argument that the industry is making there is, hey, don't make us comply with all these difficult rules until you've actually decided whether or not the rule themselves are appropriate. So put off the effective date. So that's the first thing. We should know, wow, David, one way or another within roughly 4 weeks. But as you said, we're only 2 months away from the effective date. So, I mean, we're starting to get caught between a rock and a hard place here. And then in terms of when the rules will know whether or not they're overturned or not, David, that could be a year, 6 months, or a year. And then it'll be appealed, particularly if the Democrats retain the White House. It'll be appealed to the Fifth Circuit. Then it could even go up to the Supreme Court, because all of a sudden, with the Loper-Bright Supreme Court decision on the Chevron, overturning the Chevron deference, all of a sudden the Supreme Court is now a big player in administrative regulations. And they created a mess, for better or worse. I'm not saying it was bad, but they've created a mess because nobody quite knows how to evaluate federal regulations now. They didn't give a lot of detailed guidance to the trial courts. So particularly if the White House continues with the Democrats, I think this could get all the way to the Supreme Court. So David, you and I could be having a podcast 3 years from now, wondering what the Supreme Court's going to do. We don't know. Don't bet on this stuff, people. It's too hard, unpredictable.
So let's go back to the end of the previous question. So basically, why is the industry so up in arms? Because you talked about your 3 groups. The first 2 doesn't seem like there's that big of adjustment, maybe some more documentation, different documentation than they've currently been used to. But those independent producers and the insurance industry, really representing the carriers and those independent producers, they're the ones filing the lawsuits. What about it makes them so upset?
Well, just backing up half a step first, David, nobody wants to be a fiduciary. That's a pretty demanding standard. So, I think for the big insurance companies and the broker dealers and investment advisors, they'd rather think they're doing a really good job already, and they shouldn't be held to this demanding standard. But as you pointed out, they don't have a big fight here because it's not so different than what they're already doing. Now, on to the independent producers and those insurance companies. The biggest issue, I think, is training all the thousands and thousands of independent producers around the country who don't even realize they're regulated by the Department of Labor. That's the September 23 issue, David. September 23, the rules apply what are called the impartial conduct standards and a fiduciary acknowledgement. Fiduciary acknowledgement's no big deal. The Department of Labor gave us sample language that can just be handed over to the participant. But somebody's got to tell the independent agents they have to hand it over and give them the language because they don't know. The impartial conduct standards, they're for a care obligation, a loyalty obligation, no more than reasonable compensation, and no materially misleading statements. Of those, it's the care obligation. That is the biggest change. And the place where it is the biggest change is when you recommend a rollover, you have to look at the investments, services, and expenses in the plan and see if you can do something better for that participant through, let's say, an annuity. If the participant profile, that information we talked about earlier, your website, for example, if you gather the right information, you ought to be able to tell if an annuity is really good. And then I think saying, yeah, sure, those are really good investments, really good expenses, really low, but this person needs guaranteed income. And so I think the analysis will be better, easier than people think, easier to say, no, it's not right. And yes, it is right. But the big issue is, how do they get that information? How does the independent producer in Topeka, Kansas, get information about the investment services and expenses in a 401k plan in Chicago? And that's where nothing is happening that I can tell. Well, there are a few intermediaries who are working on trying to help the agents that work with them on that issue. But that's a huge change, David. That is the biggest single practical change in the picture.
Yeah, because 401k expenses aren't always as obvious and explicit. People point to annuity expenses sometimes being opaque, but 401k also can be pretty opaque when you're trying to look at expenses.
Yeah, no, I agree, and not just, even more, that you can't. There's no requirement that a company put their 401k investments and expenses on a public website. Now, for real big plans, or not real big, but plans with over 100 participants, they actually attach a statement to their 5,500 that gets put on a public website, and at the Department of Labor website, and then other websites that you can get to for a fee. But somebody's got to know to look for them. They got to know how to look for that. Again, my hypothetical fellow in Topeka, Kansas, doesn't know any of what we're talking about right now, not because the fellow's not smart enough, just because this has never been part of his life. Yeah.
Yeah, and so it's incumbent upon who to train them: the company they're affiliated with, the insurance carrier, some combination of both.
I will tell you. I'll give you my theory on that. Let me go back to the broker dealers and the statutory employee insurance companies first. In those cases, the financial institution, the insurance company or the broker dealer, is a co-fiduciary with the advisor agent. What does that mean? It means they got to make sure the recommendation is legit, that it complies. So there, yes, the answer is real clear. The insurance company, the broker dealer, the RIA, they got to make sure, because they're the particular prohibited transaction exemption they're under, and that's just a way of saying what they have to do to handle their conflicts of interest, requires that the financial institution be a co-fiduciary. Under 8424, which is where every insurance company I'm working with is going to go for its independent producers, the insurance company is not a co-fiduciary. They have no obligations this September 23, none, nor does the intermediary, other than perhaps a commercial responsibility to help the independent producers not violate the law. But they don't have a legal responsibility. It's a practical one. September 23, 2025, all of a sudden, the insurance company has to review every application for compliance with the impartial conduct standards and with the disclosure requirements that are placed on the independent producer. Well, can you imagine an insurance company wholesale rejecting annuity applications? I would say that ain't going to happen, David. So that means they're going to have to get some pretty serious compliance assistance for the independent producers so that the applications coming in are good. I think it means the insurance companies will have to work with the intermediaries like the IMOs to train the agents. They're going to have to develop forms so that the agents can provide that information with the application. So there's going to be, I think that 1 year delay on the responsibility for the insurance companies is another reason that we're not seeing a lot of activity right now with independent producers. But boy, it'll come in full force next year.
And how do you think the DOL is going to think about enforcement? So it's one thing to put in, the regulations and require all of this. What's the discussion been around enforcement? How are they going to monitor that these things are happening and happening properly?
Well, they've got a plan, David. So here's between now and the end of next year, the end of 2025, I think if there are any cases at all, they'll come up from complaints, either individuals filing lawsuits or calling their regional Department of Labor office. For example, we're in the sort of the western region here. The office is in Pasadena, here in Los Angeles. So, but there's one in Kansas City. All around the country, there are regional offices where individuals can call the office and say, I got taken advantage of related to this plan or this rollover. That could happen. I don't know that it will, but it could, David. But that's not the plan. Beginning January 1, 2026, effectively, insurance companies are going to have to do annual retrospective reviews and reports. So that means that they're going to have to write up they're going to have to do a review of their covered transactions in the preceding year. I think what most insurance companies will do, that period from September 23, 2025 to December 31, 2025, I think they'll treat that as their first year because they'll want to be on a calendar year basis going forward. So that by June 30, 2026, they have to do an annual retrospective review, reviewing at least one covered recommendation by each of the qualified annuity applications that they approved. And they're going to have to determine if those were compliant. I mean, they have to supervise them coming in. They have to review them for compliance coming in. But then they got to do the annual retrospective review. They have to write it up into a written report. If they see any failures, they got to notify the producer, tell the producer to correct it. And so the point I'm getting to, though, David, by June 30, 2026, that'll be signed by the chief compliance officer of the insurance company. It's got to be signed by a senior executive officer. All the insurance companies I'm talking to are going to have the CCO sign it. So now you have a certificate of compliance signed by the CCO. 6, 12, 18 months later, the Department of Labor will come in and say, give me your report on your annual retrospective review. That's where the enforcement will start. It has to, David. By the time you think this all through, there's nowhere else because they don't have enough people to go out and investigate individual producers. So they're going to have to do it at the institutional level.
Makes sense. And one of the more controversial parts, of this regulation is the reasonable compensation aspect to it. And what is reasonable compensation?
Oh, David, that's easy. That's a very common concept in the retirement plan world. So, with our experience in dealing with the DOL, it's a little bit easier than you might think. Let's say for a given annuity product, 80-90% of the industry is paying between 3 and 4% front end commission and a 25 basis point trail. I'm making this up, David, but just assume that. Now let's assume that insurance company Z is paying an 8% front end commission and a 50 basis point trail. My point is, I wouldn't want to be company Z because it's that far outside the norm is going to be really hard to justify. So it's sort of like if you get in the middle of the pack, and the pack is a range, not a number. But if you get in the middle of the pack, you're pretty much by definition safe. You won't find that in writing anywhere from the Department of Labor, but I've just had a lot of experience over the years with enforcement, as other ERISA attorneys have. And that's where it really ends up. So by the time I explain it to my insurance company clients, I think they're a little bit more comfortable with it. But then our attention turns to incentive compensation. And that's where the action is. And the Department of Labor has specifically said they're concerned about incentives that involve travel and vacation destinations.
Wow, you're hitting on a very favorite topic of reps and insurance carriers.
I figured I would sort of stick the needle in by saying that,
The educational trip to St. Thomas or to Maui. Yes.
Yep, that's where, at least initially, I mean, there are all kinds of incentive compensation programs, cash and non-cash. But at least the initial focus, if we look out over the next 3-4 years of the Department of Labor, will be on travel and vacation destinations. So I don't think travel to Poughkeepsie is going to get a whole lot of attention, but travel to Paris will. So there you go.
Yes, I'll just mention as kind of an interesting aside, when I've been in talks with Vanguard and talking to Vanguard about their business and culture, as opposed to many insurance carriers, where Vanguard, and one of the guys I was talking to had come from a consulting firm, and he's got to Vanguard, and their first big executive retreat to do a strategic offsite was to the Sheraton at Valley Forge. And he said that is where Vanguard always goes for their executive retreats. And like you said, that kind of thing's not going to be scrutinized.
No, I think that one is okay by definition, David.
Yes, particularly if it's in the winter. So the incentive trips, but there is a little gray area there too, right? They're still allowing a little leeway there if there's enough education around it, or there's a curriculum, or something. It's not just pure like what do you call it, timeshare sales. If you go spend an hour in the conference room, then you've got another 3 days free at the resort.
Yeah, people misunderstand that the Department of Labor is prohibiting that. They're not prohibiting any of it. What they're saying is you have to mitigate it. And so there's, unlike the SEC with sales contests, there's no prohibition of anything by the Department of Labor, but there's a mitigation requirement. And what that means is that you have to dampen down the incentive effect to where it would not cause a person to make a recommendation that was not in the best interest of the investor. Well, that all sounds good when I say it, but how do you really apply it? And like you just said, I mean, for example, if you have a bonus arrangement, if the ranges are fairly narrow and the increases are fairly small, then that would probably be okay, particularly if there's good supervision and good processes. But what if it goes all the way back to the commission increases or the bonuses go all the way back to your first sale of the year? Well, the DOL will really look at that more closely, because they've indicated already that they think that these so-called waterfall bonus or incentive arrangements are hard to mitigate. But like what you were saying a minute ago, what if there's like 6 hours a day of educational programs? You start early in the morning, you let people off at 1 or 2 to go play golf at Pebble Beach. Yeah, sure. I think you can make that work. I mean, you'd want more. You'd want to make sure that there was a well-defined process that you were really reviewing the applications, because there's undoubtedly an incentive effect to playing golf at Pebble Beach. But I think you can do it. You just have to do it thoughtfully. It helps if you're aware of where the DOL is particularly sensitive about some of these issues.
Terrific. And so, since our primary audience is registered investment advisors, in your initial delineation of the three groups affected, you're seeing RIAs maybe as not as affected as other folks by the regulation because they're already kind of operating under a fiduciary standard.
Yes, absolutely. First off, I think the RIAs I know are very proud to be fiduciaries. They use it to their competitive advantage, and they really want to live up to that standard. In fact, to exceed it. So no, I don't think it'll affect them as much. They're still going to have to go through all the paperwork steps, the documentation, the disclosures, and I think making sure that they the SEC is becoming more interested in RIAs that are making annuity recommendations. So they want to make sure they're making the disclosures that the SEC expects them to make. But if you're doing a good job recommending the right thing, making the appropriate disclosures, I don't think it's going to be a heavy lift for RIAs.
Yeah, agreed. And one of the other things, as we start wrapping the conversation up, is around the recommendation needs to be more holistic too. Right here, it can't be just you're looking at the particular account, the account, and recommending it to roll over. You've got to have a bit more of a holistic look to the client's portfolio and their other assets.
Sure, I think so. I mean, I think if you look at how do you put a person, an investor or a retirement investor, in the perfect position based on their profile, based on their needs and circumstances. Let's say you've got Social Security as a foundation. Let's say that what's appropriate for them is to have enough other guaranteed income on top of that to meet their monthly needs. They're things they cannot do without. And so that annuity would be the second level. The third level would be longer term investing, money for flexibility for the unknown in the future. And then the fourth level would be cash or other relatively short term investments for the next couple of years. I mean, to me, at least the way I look at it, I could very easily support an advisor going through that analysis and then making a fiduciary determination about what's right for that retirement investor. It needs to be individualized, but I think that's the right concept if you're talking about retirement dollars.
And you were alluding to earlier that you spent some time on the website, you checked out the Retirement Income Style Assessment, ERISA. And how did you turn out? You like guaranteed income? Or are you more of a risk taker in retirement?
I probably on most of them ended up more on the risk taking, but David, I'm a natural born saver. I'm a better saver than I am an investor. So I've done a nice job of saving over the years. But I do think, I mean, there have been different times where I've thought that a guarantee for me personally, and even more for my wife, would be a really good thing. Quick story, my dad passed away a few years ago, and he left a lot of investments, some real property, some rentals, and some bonds and stocks and stuff. And I went to my mom and said, well, Mom, do you feel secure, financially secure with what Dad left you? And she said, no. I said, what do you mean? No, he left you, like there's all the stuff at the stockbroker and all that. She said, all that stuff just goes up and down every day. You have no idea what it's worth. And I realized for her, for who she was as a person, it was what was coming into the checking account every month. That was her financial security. And the stocks and the bonds just didn't do it for her. Now I've grown up sort of at the other end of the spectrum where I started investing in mutual funds when I was in my 20s, which was, like 1932 or something.
I don't even know if they had mutual funds at that time, Fred.
No, but so I've become comfortable with it. Yeah. with more risk than perhaps the average person is.
Terrific. Well, we think that's a neat tool, a good tool for financial advisors, trying to identify their client preferences around income and how they'd like their retirement income delivered.
Yeah, I liked the approach, David. It just seemed to me that you were really tuning in to a particular person, trying to ask questions that will give you information about who they were and what their needs were, rather than just here's your assets, here's your age, here's your income. Yes, I'm married. Yes, I mean, it went through a lot of, I think, developing the kind of profile that creates will be very helpful in justifying a fiduciary recommendation, where it indicates that that's the appropriate recommendation, much more than just the typical profile gathering form that I think is more commonly used.
Excellent. Well, anything you want to add as we wrap up here?
I'll tell you my personal philosophy, David. Nothing is ever as bad as it seems, but nothing is ever as good as it seems either. So we're gonna get through this one way or another. We'll make it through, and hopefully it'll produce really good results for workers and retirees.
Terrific. Well, I'll look forward to seeing you at one of our next meetings, maybe in DC or perhaps out in LA for a Dodgers game.
All right. We'll see you there. I'll buy you get me into the game. I'll buy the hot dogs and the beer.
Terrific. That sounds great. And I really appreciate the time, Fred.
Thanks, David.
Thanks for watching. Visit dplfp.com to learn how we can work with advisors like you. And please, for more updates, subscribe to this channel.